Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, Kent Wood of Wood & Associates, PLLC, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa, PLC. Now let's discuss some remarkable stories and real cases.
On today's episode of In the Name of the Law, we're going to talk about accidents occurring on construction sites, reasonable rights of parenting time, and we're also going to hear from our criminal defense experts.
In the name of personal injury law.
We all know that areas involving road construction or building construction can be dangerous. Unfortunately, many people are hurt in and around these areas. We have personal injury attorney Steve Sinus from the Sinus Dramus Law Firm, along with his colleagues Steve Weston and John Homa, to talk about the unique issues that come up in personal injury cases involving construction areas. It's good to have all three of you with us today.
Nice to be here.
Thank you. Thanks for having us.
So, Steve, why are personal injury cases in construction areas unique?
Well, at our firm, we handle various types of personal injury cases. And in our experience, when someone's injured in a construction area, it just brings up more unique issues. The cases tend to be more complicated. And so we're here today to try to explain that. Just in general, the issues that typically are more complicated or unique include how you establish liability, which is the ability to hold a party responsible for an injury, how to show that they are responsible. There are issues with which parties to sue. You have a construction area. There are likely many different parties that are somehow working in that area. So you have to figure out some issues there. You also have parties blaming each other. One party may say, hey, this shouldn't have happened, but it's not our fault, it's the other guy's fault. And you also have typically pretty severe injuries, just given how these injuries occur. And so there's some unique issues there. And we're just glad to try to talk to everyone about it today so they better understand.
So what are the unique issues regarding liability in the construction areas?
Well, Lisa, there can be what I like to call camouflaged liability. Let me give you a couple of examples. When we are talking about highway construction, which in Michigan, summer is construction season, but even more so now after COVID funding and additional road work is being done, there are codes and uniform standards that require that construction zones be set up in certain ways to enhance the public safety or diminish the public danger during the construction process. So if you are driving through a construction zone, following all the speed limits and doing what you're supposed to do, and all of a sudden you're hit by another vehicle, it very well may be that the driver of that vehicle was negligent in causing the crash. But it may also be that the road construction company who set up the construction zone failed to follow the Uniform Manual of Traffic Control Devices, and that as a result, they created a very haphazard and dangerous scenario that wasn't all the fault of the person that hit you. So we need to look into what happened, how did it happen, and that involves a lot of unique issues requiring multiple different kinds of expertise of individuals who work in those areas. Similarly, in a home construction, which many people are doing now because of remodeling, because spending so much time in their home the last 2 years, they said, boy, wouldn't it be nice if we could do this? Well, there are also a multi-layers of construction codes, work safety rules, and a unique body of the law that has evolved around recognizing control in these work areas between a subcontractor, a general contractor, a homeowner, and who's responsible for what aspect of these jobs. So it requires a very intense level of factual research and investigation in any of these construction areas in order to determine what actually happened and why it happened.
So what are the unique issues about who to sue, which parties to bring into the case when we're dealing with these types of construction and home cases?
Well, as Steve mentioned, these cases can typically involve multiple different parties. In the context of home improvement or building construction, you might have a general contractor, a subcontractor, and various other individuals around the work site. And more so, also in the automobile crash example that Steve mentioned, you have two separate individuals that have contributed to the harm and two potentially individuals who are at fault, but they serve totally separate roles. And under Michigan law, each party is only responsible for its own fault. And so fault is generally allocated in these types of cases.
By the jury.
By the jury or the judge or the fact finder. And therefore, if an individual who has been harmed wants to seek full redress or full compensation for all of their injuries, they will have to bring a claim against each individual that had fault or is partially liable for the harm and make sure that everybody is involved so that there is not an empty chair or somebody that fault could be attributed to that's not part of the case, which ultimately would lead to the client or the injured person not receiving full compensation for their injuries.
So Steve had mentioned that the parties can blame each other while they're trying to defend their own actions. How does that work?
Well, as John just mentioned, it's the job of the fact finder in any kind of litigation ultimately to determine who was at fault in causing the injuries and damages and what was their percentage of fault. So to the extent that a subcontractor can blame a general contractor, or to the extent that the at-fault driver in a road construction case can blame the construction company or the Michigan Department of Transportation, they can reduce their percentage of fault and therefore not have to compensate out of their own proceeds the injured plaintiff. And that is a regular occurrence that happens. And because these scenarios, whether home construction or roadway construction, have developed a complicated legal framework to assess who had what duty to carry out what action, it puts the onus on the injured party's attorney to really be familiar with all of the statutes, codes, and law that have been developed to apportion responsibility for safe passage during these road construction areas and to properly and fairly apportion responsibility for safe work areas in home construction. And without knowing how to go about that, as John mentioned, you may be suing the wrong party. You may be suing 2 of the 5 parties that need to be involved in order to obtain full compensation. And so those become very important decisions early on, which is why if you have time limitations, it's really important to include everybody so that time limits don't preclude you from later finding out, oh man, I should have included this party or that party. And that's the assessment that the attorney needs to make.
So let's talk about the severity of injuries in these cases. Why are they more severe in these cases, and how does that impact the case?
Yeah, and to kind of wrap it up here with our time left, let's not lose sight of what these cases are about. They're about people who are typically severely or if not catastrophically injured. And so while you have to sort out all these other issues with fault and naming the right parties, you have to get to know your client's injuries, the nature of the injuries, their prognosis. These cases also can include medical expenses, so you have to get life care plans. So there's this whole other issue of working up the damages in these cases that takes a lot of time and effort by the attorneys involved.
That's helpful, and thank you for helping these severely injured people.
Thank you for having us.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. In the Name of Criminal Defense.
I have criminal defense attorneys Mary Chartier and Takura Nyan-Fakusta with me. You've handled some interesting cases involving the use of electronic devices and have even used electronics to defend cases. It sounds like electronics play a big role in both the prosecution and defense of people accused of crimes. So let's talk about what we need to know about this area. First, what are we talking about when we refer to electronics?
Thank you, Lisa. So a lot of the usual suspects, right? Cell phones, laptops, iPads, but also GPS, right? Including GPS on cars and the phones, even Apple Watches for heart rate monitors, the pitter patter, was somebody asleep? Was the person running somebody down? Alexa searches, right? They listen to everything, and different apps on phones. It's expanding quite a bit.
So it sounds like the use of electronics has changed quite a bit over time.
Tremendously. It's so different from when I first started practicing. And one of the most interesting changes, and honestly, to me, one of the most frightening changes, is something that a lot of people don't know about, and it's called the geofence warrant. And we recently litigated this issue in federal court.
Can you say that again?
Sure. It's called a geofence warrant. G-E-O. You're going to make me spell it, and then fence, F-E-N-C-E. I feel like I'm back in like the spelling bee. And my word that I couldn't spell was little. I could not ever remember the E at the end. Now I can. So it's a geofence warrant.
Okay.
And essentially what it is, so if the police believe that a crime was committed in a particular location, so let's say, there's a robbery at the corner of, X and Y street, then what they do is they apply to Google and they look for, and they ask for, and they get a subpoena, they get, they get a warrant, and they get the phone numbers for everybody for a particular time who is at that location. So they could scoop up your phone number or mine. So they could get 5 numbers, they could get 50 numbers. Then they'll go and get a warrant and ask who those phones belong to. And then they will from there work their case to see, okay, well, one phone belonged to Mary Chartier. We don't think she's the person doing the robbery, but okay, well, this person, they run his criminal history. He has a history of robberies. So now they're going to look at that person as a suspect. So they really just like sweep up all this information. There's a judge in Virginia in federal court who ruled that as it applied to that case, it was unconstitutional because there wasn't enough particularized information, but the evidence could still be used because of the good faith exception. So essentially, it's like taking your cousin to the prom, right? The guy won in court, but the prosecutor can still use the evidence to convict him. We lost our case in federal court. The judge said the geofence issue was a fascinating issue, but he believed, and so is still open to holding that in some cases it might be unconstitutional. But in our case, the court held that there was a particularized basis because it was at night. And so they really did not get a lot of phone numbers in this location. It hasn't gone up to the U.S. Supreme Court yet, but it will. I think it definitely will. And those are the only 2 federal cases that I know. But this is being used throughout the country. Google has now said that 25% of their warrant requests are geofence warrants. And that's really frightening because if you're in the location where the police believe a crime was committed, now they can track you to that location.
Now, I wanted to know, could they find out potential witnesses to a crime and then go use that information to go start investigating and questioning witnesses?
Okay,
sure.
Yeah,
absolutely.
Just because your phone happened to be nearby, maybe.
Right. And what's interesting is, you don't have to have something, as long as it's enabled on your phone, you don't have to be actively using, Google location search where you typed in an address. As long as it is enabled on your phone, they can get that information, and they do.
Wow. So that sounds like a really important area to keep an eye on. What else is going on with electronic devices in the criminal defense world?
So if you think for a moment about the amount of information that a phone holds. Law enforcement, without a great deal of resources, certainly not spending as much time following somebody, can gather information about where you bank, what you eat, messages that you share with your family, what you do, when, for how long. Just think of all the things that you do on the phone and the amount of time and people that they would otherwise have to use to gather that same amount of information that you literally hold in the palm of your hand. It's a super computer. So cell phones, computers, major phone dumps. And when I say tens of thousands, I mean this literally, not figuratively. We have read phone dumps with tens of thousands of pages. Searches, deleted messages even get recovered. The government uses these to prosecute, to challenge alibis, and make the case for who was at the scene, as you mentioned a little bit ago. They read every single message. So whether it's, hey, I'm picking up groceries or something else that I won't mention on network television, they they read them all. And code words don't really help, whether it's shoe or anything like that.
No, we have read so many, as Takura said. So a phone dump, we might get 50,000, sometimes even 100,000 pages of text messages, and it'll show if a message was deleted. It will say deleted, but the message will still be there. These are used a lot in drug cases. So we had the one where the code word was shoes. And, the client said, well, I never said anything about drugs. You didn't. But unless you're the cobbler in your town, people are coming to your house every day for shoes, right? And people would only want one shoe. They'd be like, listen, I just want one shoe today. I mean, again, unless it's a bunch of one-legged men running around the town, it's pretty clear this is a code word for drugs. A lot of people think too that like Snapchat, the police can't recover anything from that. We heard that about WhatsApp. That's not true. Snapchat, it is more challenging, but they can recover some things from that. But we've also used electronics to defend people. So as Takura said earlier, right, the Apple Watches and Fitbits have been really helpful. We've used GPS on phones to say, okay, well, this person is saying this, that our client was at this location, and the GPS doesn't have to be activated. We've been able to show that if they're driving from point A to point B, they've been at a particular location. So we've used it quite a bit. And we've also been able to use body cameras. So when we're talking about electronics, the police are actually using body cameras now, and their dashboard cameras, and they're communicating by text messages and emails. And when we do discovery requests and Freedom of Information Act requests, we've been able to get that to show that there have been issues. And we've used it also to challenge DNA. We got DNA that supposedly matched our client to the scene when we got the underlying file. We saw the email exchange between the analyst and the analyst supervisor, in which the analyst said there was a problem with contamination of the run. And the supervisor said, we'll still run the report, but you have to notify the attorneys. The attorneys had not been notified, the defense hadn't, and neither had the prosecutor. So we were able to use that to show that the DNA match was flawed and the case got dismissed.
Are there certain apps that protect people more than others?
I mean, again, Snapchat is probably better than most, but people can't have any faith in knowing that, or if they're communicating by Snapchat, because someone can save something on Snapchat, they can take a screenshot of it. The police can still access some of it. So I think people need to be aware that what they are communicating is not necessarily private and confidential in this day and age. I mean, electronics has changed the landscape, both in prosecuting cases and defending them.
So what are some other issues with phones and computers that we should be aware of?
Big issue with sending and receiving nude images if somebody is under 18. So this happens at middle schools and high schools all over. This is child pornography. Sex offender registry and prison time can follow.
Right.
Okay, thank you for sharing that.
Thank you, Lisa.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Niamfakusa PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
We are here today to talk about reasonable rights of parenting time. I have Kent Wood, the owner of Wood & Associates. Now, Wood & Associates practices in several counties, including Ingham, Eaton, Clinton, Calhoun, Kent, and even Branch County, but the reasonable rights of parenting time really could be helpful to anybody all over the state. So welcome, Kent. Let's talk about reasonable rights of parenting time.
Okay. Well, this comes up when you're in a custody issue, a parenting time issue, or a divorce matter. And you can't agree on a schedule, or you're disputing what's going on. And unless the parent, the non-custodial parent, so the custodial parent has the majority of the parenting time, but let's say the non-custodial parent, unless they're like some bad person who's done something harmful to children or other children, or has just can't survive on their own, let alone take care of children, they're going to get what's called a reasonable parenting time schedule, because everybody has a right to parenting time. Mm-hmm. And each county has a variation of a reasonable parenting time schedule. This is kind of the...
So what is reasonable might depend on where you live.
Right. A
okay.
little bit. Well, they're very similar, but yes, what's considered reasonable in terms of if there's no fight is kind of an every other weekend schedule. Mm-hmm. Midweek visits, usually on Wednesday if you can't agree. Then alternating holidays, mm-hmm. and they're usually the same holidays for every county. Alternating birthdays, and then some sort of extended time in the counties. And that's where I see the biggest difference is how they handle the summertime. For example, Ingham County gives you an extra week every month in the summer. Mm-hmm. And then Eaton County gives you like 4 weeks in the summer, with that extra week happening in July. And we found out in Calhoun County, it's kind of default for the summer is a week-to-week schedule. So it's
like week on, week off?
Yes, week
okay.
on, week off.
Okay.
That's what we've seen kind of play out in the different counties. So it's all kind of follows there, but that's what they call reasonable parenting time. But we're starting to see that change more and more in terms mm-hmm. of what that looks like. They're giving more deference to children that are 15 or older if there's any kind of change in parenting time. But it still comes down to, can the parents agree? What are your work schedules? What's the child's schedule? Mm-hmm. And just what have you been doing? And so those all are big factors that need to consider when we are helping somebody and advising them on, hey, look, this is what the reasonable parenting time is. Should it be anything different? Is this something you can do in your schedule? Does this accurately reflect what the parenting time arrangements were when you were together as a couple, right? If you were there sharing our responsibilities 50-50, maybe a 50-50 schedule makes more sense. Mm-hmm. But we have to look at the factors of that. But the world's also changing around this reasonable parenting time schedule as well, especially with schools. Schools seem to be going more and more towards a balanced calendar, where summers become shorter. Mm-hmm. So when you have these schedules that let you share the summer, get extra time in the summer, that starts to disappear when summer is starting at the end of June, but school starting at the beginning of August. You're down to like 5-6 weeks when it used to traditionally be kind of a 12-week summer almost. We also see other holidays becoming more and more prevalent in our whole country. I guess the word. I know that an important holiday, Juneteenth, just passed, and that was one that I saw more and more schools this last year, and even federal buildings, everything, take that off as a holiday. That's not a reflected holiday in the schedule of the holidays that are normally provided for in the alternating schedule. So that is something that we advise people, if there's holidays or events in your own religious beliefs as well that aren't reflective in a standard schedule, when you're setting the schedule up, that's the time to bring it up, to present it. And it will be considered reasonable to share those important annual landmarks, I guess, mm-hmm. is what a good way to say them every year. Other thing that is happening is with the school schedule is that there's more and more of these longer breaks, right? When the summer gets shorter,
right.
There's midwinter break.
More five-day weekends.
Right. More 5-day weeks, more
mm-hmm.
whole weeks off, right? Thanksgiving in some places is not just a Wednesday to weekend thing. Mm-hmm. It's now becoming the Friday before mm-hmm. the whole week. So that's not reflected in the reasonable parenting schedule. The courts are slow to catch up to those changes. And as those changes happen, we believe that they should be in there. And when we represent you, we make sure that you've considered those and have included all of those potential extra times to make it happen.
Yeah, and I think I've heard a lot of parents say that, the reasonable rights of every other weekend and Wednesdays is just, it's not reasonable at all. That's not enough time to be with their children.
Oh.
But that's where the attorney can come in and argue or explain why another schedule might be more appropriate, right? That's kind of the baseline.
Right.
Baseline schedule.
Oh yeah, it's kind of a baseline based on the history and work schedules and old traditions and norms of one parent going to work 5 days a week and the other parent staying home. That's kind of, and that world's changed and is rapidly evolving. If you have a homeschooling schedule, maybe you don't need, you can do week to week and it not be an issue. If you have an online classroom of some sort, you can have a lot more flexibility and that's with people, more and more people working from home, refusing to go back to the office and leaving jobs to stay at home. That's just opening the idea. So I always tell people, be the parent you would be if you were a single parent, right? Because the biggest factor a lot of courts look to, especially Ingham County and Calhoun County, is what were you doing when you were together? We're going to try to mirror that afterwards for the child. If you were, busy working 30, 60, 80 hours a week, well, then you weren't there anyway, right? But if you were adjusting your schedule and making it work and going to work in the mornings and coming home in the afternoons and dealing with things and making sure they got to appointments and stuff, they're going to want that to continue. The court will support that.
Do you see a lot of judges that they decide parenting time just by referencing the reasonable rights that are each county's has them posted somewhere, or do you see more judges actually kind of crafting a schedule?
It really just becomes on if you're willing to take the initiative to be there and present it to the judge.
Okay.
If you're not there, you're going to get a reasonable parenting time schedule, right? This is what you're going to get if you don't show up, kind of a thing, unless there's something drastically hindering your ability to be a safe parent. But if you want something different, courts are very open and considering it more and more. Even in the 15 years I've been practicing, in the last 5, I've seen it more and more willing. Hey, what's been going on? Taking it more and more at face value and being fair and wanting to see some more evidence instead of just taking one side's, the bias to one side or the other.
Right.
So there's a lot of great things happening for the parenting time schedule, but again, it's the child and it's your relationship with the child.
Right, and it's also the age of the child, right? That's going to be a huge factor because every other weekend may not even be appropriate if you have an infant, for example, right?
Remember, it's always what's best for the child. And even now, more and more courts are adjusting their reasonable parent time schedules to include a special schedule from 0 or birth till 2,
right?
Especially if there's breastfeeding involved.
Well, and it's not just the counties. The state has come out with the statewide parenting time guidelines, and I don't know how many of the counties are incorporating those ideas.
Slowly.
Yeah.
That's slowly happening from what we see. Some are right on with it, and others are hanging on to what they've known for the last.
Which makes being an attorney fun. You just have to go all over the place and figure out what everybody's doing differently,
right?
No matter where you are in Michigan.
Right. Well, if you're going to advise your clients, well, that's what you got to do.
Yeah.
So,
great. Well, thank you for this helpful conversation, Kent.
Thank you.
In the Name of Family Law is brought to you by Wood & Associates, PLLC.
Thank you for watching In the Name of the Law. We look forward to seeing you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.